Hello and welcome to our Spotlight video series where we discuss cutting-edge employment law issues in the news. I'm Tom Spiggle, founder of the Spiggle Law Firm, a firm that helps people who've been fired or afraid that they might be. I am thrilled today to be joined by Valerie, one of the senior attorneys in our office. So Valerie, what are we going to be talking about today?
Good afternoon, Tom. Today we're going to be talking about the recent return to work mandates and how those mandates are impacting employees with disabilities.
So what kind of things are you seeing with people who are calling us?
Sure. One of the main things that we're seeing is that people with disabilities, particularly people with mental health disabilities like depression, anxiety, PTSD, they are concerned because their employer is not allowing them to work from home on a full-time basis. And what has happened is that during COVID, most companies allowed their employees to work from home on a full-time basis. Now the employers they're pushing back. They're saying, nope, we want people back in the office. We've seen this with Amazon, with Disney, with Google. And whether it's a 5-day return to work mandate or a hybrid where it's 2 or 3 days back in the office, this is becoming more and more of the norm. So the way that that's impacting people with disabilities, especially people with mental health disabilities, is that the employers they're saying, no, we want you back in the office. It is not enough for the employee to say, well, hey, employer, during COVID, you allowed all of us to work from home, so what's the big deal now? The thing is that with people with disabilities, in order to be granted an accommodation, which working from home, that could be considered to be a modification of the work environment, which is considered an accommodation under the ADA. So in order to still have the ability to work from home post-COVID for people with disabilities, what they have to do is to request a reasonable accommodation. And again, that accommodation is working from home. And in order to do that, they will more than likely have to get documentation from their doctor saying, working in the office, it exacerbates the patient's depression, anxiety, etc., to the point where they can't function or they can't perform the essential functions of their position. So the doctor then writes on the medical documentation, my patient can perform the essential functions of his or her position as long as he or she is able to work from home. The employee then presents that to the employer, and the employer has some options. The employer can say, yes, that's fine, that works for us, your accommodation is granted. Wonderful. The employer could also say, no, allowing you to work from home 5 days a week, that's going to impair our ability to serve customers. What the employer is essentially saying there is that allowing you to work from home 5 days a week is causing us to suffer an undue hardship. But that is not in the inquiry. Then the employer and the employee, they engage in what is called the interactive process, which is basically a process by which both parties work together to determine an accommodation, which one does not create an undue hardship on the employer, but also is an effective accommodation for the employee. It's not enough for an employer to offer an accommodation to an employee when that accommodation is not effective. In other words, when it does not enable them to perform the essential functions of his or her position. So in this scenario, the employer and the employee could be working back and forth, engaging in this interactive process, and they arrive at say, okay, you don't have to come into the office 5 days a week, but 3 days a week. And if the employee is able to manage that, according to their health condition, and if it enables them to perform the essential functions of their position, then it's a win-win. The employee goes back to work in the office 3 days a week, works from home 2 days a week. It does not create an undue hardship on the employer. But again, it has to really meet both criteria. It cannot create an undue hardship on the employer, and the accommodation has to be effective. And that's not always, well, typically that is not an easy balance to achieve, but that is the goal.
Yeah. I mean, I think it's interesting too. I think one thing with, certainly since the pandemic, I think it's more difficult now for employers, right, to say, I guess it depends on the position, but pre-pandemic, right, there's
Hmm.
select few people who are using, working from home, using video conference. Of course, during the pandemic, everybody did, including the courts,
Right.
right? So you had these crusty old judges, who are having to figure out how to use Zoom along with the rest of us. And
Right.
so I think now there's much more, and you may have seen some of this in your practice, an understanding that work from home is not this huge, right? Like we've got Zoom, we've got Slack, we've got all these
Hmm.
different capabilities now, and people are used to using those. That doesn't mean that an employer can't force you back in the office, or that they have,
Right.
like you said, like they have to let you work from home. But I think now you get at least a fair shot, from the court system if you're saying, hey, look, this is not an undue hardship on the company because we all worked from home for a
Hmm.
while. So that I think that's helpful. And then, I think the other piece is like that you mentioned, some things that I know that you've seen, we see in our practices where employers really step in it is they don't engage in the interactive process at all,
Correct.
right? Which is a violation.
That is a
Yeah.
huge violation of the ADA. They cannot just simply throw up their hands and say, "Nope, we're not going to grant the accommodation," and end it there. That will get
Yeah.
them. That's almost a per se violation of the ADA.
And we see it, right? We see it where
Yes.
companies don't understand their role and they're like, nope, my way or the highway.
Hmm.
And that doesn't mean they have to grant your accommodation, like you said,
Right.
but they've at least got to come to the table. And I think you made a good point, like for the employee, for people that we represent, don't have an all or nothing position on your end as well. Like think
Hmm.
creatively about, with your doctor, because if
Right.
you come in with an absolutist position, like I'm to be at home 5 days a week. I mean, if that is what is required, you got a doctor to back you up, okay, that's one thing. But if you can say, okay, I can, I can come in, I suggest coming in 3 days a week, right? You
Hmm.
kind of give and try to find, kind of meet them in the middle. And I think you're more
Right.
likely to get your employer to play ball if you come in with that sort of attitude.
Right. Yes, that's exactly right. I mean, the employer is not required to give the employee the exact accommodation requested.
Right.
So, if there's a way, again, to make it so that the accommodation is effective, and also so that it does not create an undue hardship on the employer, that that is what that is what the ADA requires.
Yeah,
So yes,
absolutely.
the employee, they just can't give up their hands and say, nope, my employer didn't allow me to come to stay to work at home 5 days a week, so I'm going to sue them for violating the ADA. Then
Right. You're going
both
to lose
parties
that.
have to engage in that interactive process.
Yeah, absolutely.
And
And
one thing
that's
I
where I
wanted,
think sometimes, yeah, go ahead, Valerie.
oh, I was just going to say, yes, you're exactly right that the fact that so many companies were allowing their employees to work from home during the pandemic, yes, that does create the context now, and it does make it easier for people with disabilities to make that accommodation request to work from home. But that is not the be all and end all either, because
It
an
certainly
employer
isn't.
can come back and say, yes, we did that during the pandemic, but it created more customer complaints. It resulted in lower productivity, so that they can still come back with those undue hardship arguments, even though they may have allowed all their workers to work from home 5 days a week. Rest assured that in all likelihood, their employer is going to come back and say, yes, we had to because of COVID, but these were the impacts on our business. And, things have changed now. So it's not going to be just relying on that fact alone is not enough.
No, absolutely. Yeah. And then we see, obviously, even just in the popular press, not even just about employment law, there's a lot being written now about the benefits of, in office. And, I think we all learned the technology to work from home during the
Hmm.
pandemic. We all saw the downside of that as well.
Right.
So you're right. It's certainly not a silver bullet that like, hey, you did this in the pandemic, so therefore you should let me continue to do it now. You've got to bring more than that.
Right.
Our
Exactly.
time is up, but this has been very interesting. I appreciate you talking about this. Is obviously we see this a lot in our practice, and I think
We do.
as we as a society continue to struggle with this balance between working from home and working in the office, this is going to be a continued issue, I think.
It will be, absolutely. Well, thank you,
All
Tom.
right. Yes, I'll let you get back to the next thing on your desk.
All right. Bye bye.